The closure of factories and ports and the declining demand for energy is adversely affecting businesses worldwide due to COVID-19. And this is seriously affecting the world economy and people's social lives.
This is particularly true with respect to agreements or contracts entered into before the outbreak of the virus, whose performance has been disrupted as a result of the restrictions that have recently come into effect.
Also, since a force majeure clause typically excuses one or both parties from performance of the contract in some way following the occurrence of certain events, we will be finding out legally if businesses can rely on force majeure clauses for COVID-19 related disruption in relation to contracts entered into after the occurrence of the pandemic.
And to do justice to this topic and other issues centered around rights and force majeures is Onyekachi Ubani, a legal practitioner and former chairman, Nigerian Bar Association Ikeja branch. It's a pleasure to have you. At first, let us even have a sense of how this is playing out legally. You know, I talked about the fact that you can call it a minute form of force majeure. My caretaker, normally at the end of every month, will send me a bill on how my service charge is being used. But since this COVID started, I have not seen that bill. I'm excited about it. I wanted to ask, but you know, like they say in Nigeria, don't be too forward. So I just kept it on the low. So does it mean that those 2 months are waived for me? Can you just explain what is happening now?
What has just happened to Nigeria and to some of the countries in the world is something that is clearly new in this particular generation. Of course, we know of the issue of force of nature. I mean, the handwork of God, you know, issue of force majeure when things like this happen in a contractual arrangement. So I think you need to hear from the landlord or whoever you are dealing with, whether there is a issue of allowing you not to pay for your bills within these 2 months that this thing has actually kept everyone at home. It's very important. Now we're talking even of the issue of energy light. There has been this debate forth and back as to whether we are going to be charged for the month of March and April, and that has not actually been resolved. And so you have to hear from your landlord, you have to hear from the person that you are owing, you have to hear from your bankers whom you have borrowed money from, whether they have actually put a moratorium as to payment of your outstanding bills or interest or amount of money that you are owing. So if you have not heard, you know, so be not hasty to rejoice that your bill has been written off until you hear specifically from the person you are dealing with. But as I tell you, if the matter goes to court, if it is contract that has actually envisaged force majeure, you may be able to succeed in the court of law to prove the point that this thing was never anticipated, and being the handiwork of God over this issue, you are not in any way liable. And then the court will take evidence before you reaching judgment. So don't be in a haste to rejoice over this until you hear from your landlord.
Yes, Rufai, go get your rent ready. Mr. Ubani, before, I'd like to take you back to the clause and how it implies, but let's take a step backward for now. For the benefit of our viewers who may not understand what force majeure is, please explain what is force majeure and how does coronavirus pandemic apply under force majeure?
It's usually in contractual arrangement. What it means is that you have entered into a valid contract with a third party, and of course you expect that contract to be executed in accordance with the terms and conditions of that contract. But along the line, some other situation occurred, just like this pandemic, which was clearly maybe never envisaged in the contract. And when it does occur, it does now put a hold to the due performance of that contract. And if it does, especially where time is of essence, if you are asked to supply a material and there is a timeline for that, maybe for 21 days, and within the 21 days, this particular pandemic occurred, and you were not in any way opportune or in a position to supply, it is now called the force majeure. It is now this issue of unexpected incident has now occasioned to disturb the due performance of that contract. So that is what is called force majeure. And when it does occur, now you are exculpated from liability over the performance of that contract. As I said earlier, especially where time is of essence in the contractual terms of that agreement.
Welcome back to the Morning Show here on the Rise News. We are still discussing the legal implications of coronavirus pandemic, force majeure, and Monday, Onyekachi Ubani, a legal practitioner and former chairman, Nigerian Bar Association, Ikeja branch, Lagos, Nigeria, is online with us. Shaitan, you do have a question for Mr. Ubani.
Okay, so I mean, we now understand what force majeure is, and we understand the eventualities that it could come up in. However, I want to talk about tenancy agreements because, first of all, it's very personal to me, and it's something that a lot of people seem to be going through at this time. So in a situation where your contract doesn't specifically address a pandemic as a force majeure, what happens then? We did see a number of people who were going back and forth with their landlords because they were being forced out of their homes even during a lockdown. In a case like that, what happens?
Well, I know that the arrangements in Nigeria for issue of tenancies is a yearly thing. It's hardly a monthly thing. And if you are supposed to pay an annual rent, I don't know whether for these few weeks of the pandemic, in which people are locked down in their homes, will be an exculpating clause for you. I'm yet to hear from Nigerian landlords. I manage houses, and I don't think I've written to any of the tenants that I'm going to excuse them from paying their tenancy, the annual rent, because of this pandemic. In any case, we don't even know how long we're going to be holed up in homes. Even though the federal government has announced that from Monday, that is 4th of May, some businesses will begin to operate and open. They're trying to open up the economy. I don't know whether these few weeks of interlude, so to speak, will be enough to exclude liability for any tenant within Nigerian economic sector. As I said earlier, what we do pay here is an annual rent. If it's a monthly payment, you can have some level of argument with your landlord and say, look, for 2 or 3 months now, I've been at home, I have not been able to work, and I have not been paid any salary. A humane landlord will look at it and say, okay, for these 2 months or a month, you are excluded from being paid, from paying your rent. But if it is an annual thing, and for these few weeks, I doubt whether any Nigerian landlord will actually exclude a tenant from paying his annual rent.
The follow-up I wanted to have to that is, what about people paying mortgages? What applies to that?
Mortgages.
Yeah. What about people paying mortgages?
Mortgage is being handled by there must be a federal government guideline. From central bank as to issue of payment of this interest and payment of even the substantive loan within this time. And I think there has been an individual arrangement by the banks with their customers, giving some level of moratorium for some time on issue of repayment of debt that you are owing the bank. And so there must be a policy statement by your various bankers who may have given you the mortgage loan as to whether you should not be liable at this time for these few months or few weeks, depending on when the economy will be opened up. If we're going to stay at home for more than 2 or 3 months, so I think there should be a coordinated guideline, especially from the central bank, as to the mode of repayment of mortgage loan. That is what I think, or Federal Mortgage Bank. Federal Mortgage Bank is actually in charge of loan arrangement with regards to mortgage. So I expect a very coordinated guideline with regards to repayment of mortgage debt by people who have borrowed money to buy houses and properties. So I think that should be the best thing to do. But in the absence of that, I think you have to now work out an arrangement with your individual bank who may have given you the loan for the mortgage.
I need further clarification here. For those who have not inserted the force majeure clause in their contract, can it be implied, yes, or is it too late to imply or apply the doctrine? And then in solutions, speak to us about the doctrine of frustration. Is that a solution for people who will be facing contractual agreements in this period?
Yes, as I said earlier, if it is not specifically provided for in any of the written agreement, but the reality is that these things, were never really anticipated and they are just suddenly occur. It becomes a matter of evidence and before the court as to, what should be the contractual obligation of parties when it goes to court for adjudication. But parties can also resolve this matter ordinarily through ADR, alternative dispute resolution. They can sit down and say, look, gentlemen, look at what has happened. We never anticipated this, and this has not occurred. And am I expected to go ahead to perform this contract in the light of this reality? So it's when you fail to agree during the ADR that people resort to judicial adjudication and interpretation of what has actually occurred at this point in time. But if parties can also look at the reality and understand themselves and appreciate the fact that this thing was never anticipated and it has occurred, and it may not in any way engineer the performance of a particular agreement or contract. It's just it's all facts. Facts will determine what parties will like. If they agree, fine. But if they don't agree, the matter will end up, before an impartial tribunal or court, who will now look at the issues and look at the facts and look at the evidence adduced by parties, after which a sound and reasonable judgment will be given as to whether exculpating an individual in this time or. So facts usually is key, because if we don't have facts in order to adduce evidence to give the court an opportunity to look at issues holistically, it will be very difficult for me now to make a conclusive pronouncement as to what will be the legal liabilities of parties when this particular pandemic, ends or subsides.
In a situation like this, I'm curious to know who claims relief, because we do know that the whole point of having a force majeure is to make sure that for that situation, there's some sort of relief. So is it the contractor or the contractee? At this point, is it the court that decides who claims relief that comes from force majeure?
Yeah, it depends on what you agreed as terms of contract. As most times is usually there is a contract. A contract that is hired by a party to perform an obligation, after which you are paid. Now, you are not able to do that particular contract, within this time because of what has happened. Would it be right for you to claim monetary, your fees when you have not performed the contract? As I said earlier, facts will determine what will be the decision of the court in case the matter goes before the court or before any arbitration or any arbitral tribunal. They will look at the facts of the case. What are you claiming? Who is actually trying to claim, what probably has not performed? But I know that when force majeure like this occurs, it then means that the contract is put in abeyance. The terms are put in abeyance. You're not able to perform. Will it be right, if you're not able to perform, to ask for full payment of fees on the contract when you have not done what you are supposed to do? So what has happened in the issue of force majeure is that nature has come to intervene and now has made the performance of that contract to be practically impossible. And so when it becomes practically impossible for the due performance of that contract, the issue now is who will now want to go and insist that the other party should now, perform, do what it's supposed to have done by way of either performing the contract or payment of fees for the contract when the contract has not been duly performed. So it all depends on the facts of the case. So the facts of the case will determine what the court at any point in time will read. But it's important we understand what force majeure is all about. That nature has actually intervened, now negating the performance of few terms of contract that is fairly agreed by parties. There is offer, there is acceptance, that may have been intention to create legal relationship and maybe consideration. If you have paid, if you have made part payment, and the man is unable to perform the contract, maybe that is where your question becomes very relevant. Will the man now ask for the return of the money, or will he now insist that the contract will still go ahead to be performed after the issue has actually cleared? It depends on the facts of the case. If a part payment has been made and pandemic ends, it's expected of you now at this point now to perform the contract. It will be wrong for that individual to insist, oh, since the contract was not performed, that you are liable. No, he will give you an opportunity to perform the contract since it was not performed at the time you wanted to perform it due to some unforeseen exigencies. So you are given the right to go ahead and perform it. It will be wrong for you now after the entire thing has ended. You say you're not going to perform and you still want to keep the money of that particular person that has paid you. So I think this is where legal dispute will arise that would require adjudication by the judiciary.
Okay, in the spirit of force majeure, I still want to talk. I also want to talk about constitutional force majeure on the citizens. You know, because the Constitution is a social contract, and a lot of people will say, "Oh, it's a force majeure because my rights are being breached, my fundamental human rights are being breached because of the urgency of the pandemic." And I also want you to segue this into explaining the tenets of the Quarantine Act.
Yeah, the Quarantine Act is a law in Nigeria. I think it was enacted in 1926. It is a law that is made to deal with the issue of infection within community, within certain areas. And of course, it is meant to actually stop the spread of infectious diseases. That is the purpose. It's an act of the National Assembly. It's different from the Constitution that is a ground norm that makes elaborate provisions as to constitutional rights of the citizens. Now, you cannot in any way use the Quarantine Act to abridge the rights of citizens that is expressly provided under the Constitution, except you have had a recourse to Section 305, which has to do with the issue of emergency. Where there is pure emergency situation in the country, the president has a right to declare state of emergency and transmit the gazette to the speaker and the president of the National Assembly, who now probably look at it and probably pass a resolution agreeing with the president on the terms and things he has prescribed for the issue of emergency. But if the president has not had a recourse to that section and then purposely want to act under the Quarantine Act, it is still debatable whether he will use the Quarantine Act, which is a lesser law, to infringe on the rights of citizens that is expressly provided by the supreme law of the land, which is the Constitution. Because even the Constitution itself pronounces its supremacy in Section 1, subsection 3. And of course, the law says that this Constitution itself says if there is any other law enacted by the National Assembly.
Okay, Barrister Ubani, just want to tell you have 30 seconds. We'll continue with you, but just keep speaking so that when I interject you...
well, let's just go on the break now.
Okay, we'll just go on the break now, okay?
Yes, stay with us.
All right, welcome back to the morning show right here on Rise News. We've got Mr. Onyekachi Ubani, a barrister, is here with us. He was just finished on the point, and I'll talk some more before we move on to the other guests. So you were trying to make a point about the Constitution and Quarantine Act.
Yes, as I was saying, if the Act, and I understand now is undergoing some level of amendment in the National Assembly, if the Act turns out to infringe on any provisions of the Constitution, especially with regards to Part 4 of the Constitution that deals with fundamental human rights provision. Any person that is threatened or is likely to be affected by that law has a right to go to court, to ask the court to declare that law inconsistent. And when any act is inconsistent with any provisions of the Constitution, it will be declared null and void by the court. And so even though it's undergoing amendment, it is also imperative that those who are amending the law take into cognizance the provisions of the Constitution and do not in any way enact any law that will clearly be inconsistent with the provisions that deal with fundamental human rights. So it is very imperative we know that Quarantine Act is an act that deals with issue of infection and spread of it. It is not a law that is giving any person, either the president or the governor, right to begin now to violate the rights of citizens as provided for by the Constitution.
Mr. Ubani, is it correct that some force majeure require that you give notice, even though it is common knowledge? Once the event has happened, you do have to have given notice ahead. Explain to me what exactly this means, that you should have given notice.
What it means is that when it's occurring, I mean, this thing is so sudden, and you have a contract to perform, is it not? And thank God we still have technology. You have email, you have, I mean, you guys are interviewing me now with technology. and you have the address of the people you are dealing with, there's nothing wrong in, bringing to the notice of that individual what has actually occurred. It's, even though that this one is of public knowledge, there are force majeure that it may only be peculiar to the individual. He only knows that particular thing that has actually occurred that has made it practically impossible for performance. And so that's why issue of notice is key. But in this one that is not, the whole world is affected. There is no one that is not, aware. Maybe for sake of legality also, there's nothing wrong. It's also bringing to the notice of the contracting party that this is what has occurred, or this is what is occurring, or making it practically impossible for me to perform the contract. So as I said earlier, there may be some level of force majeure that will occur that is only known to you, which is work of nature and is only known to you. And you have to bring it to the notice of the other contracting party. But this one that is public knowledge, everyone knows. There's nothing wrong also in erring on the side of surplusage in giving notice to this person you are dealing with. Look, because of this, I am not able to perform my own side of the contract and all that. So maybe that is where the issue of notice is key. Let the other party know what has made it practically impossible for you to do your own side of the contract.
Very well said. I mean, you did highlight on this earlier, but I'd like you to break it down. In a case where the contractor intends to force the other party into performing their contractual obligations, is there need for mitigation, and what would be the scope of that? And then also, I would like to know, are there other alternatives for a force majeure clause?
I don't know what you mean by other alternative. When nature has intervened in a thing that was not clearly anticipated, as I said earlier, what does occur is that you bring to the notice of that individual what has actually made it practically impossible for you to do your own side of the contract. And then if the man does not agree with you, a legal dispute is disclosed. And of course, you have to now have recourse to all the alternatives for redress, either through alternative dispute resolution mechanism, or you go straight to litigation, after complying with whatever agreement was reached by both of you. I mean, terms now usually provide specifically for all these alternative dispute resolution mechanism before you have to have a recourse to litigation. And so you have to now, give notice of what you think has actually arisen that has created dispute and what should be done to resolve the matter. My statement, which I still hold clearly to, is that if there is possibility of performance of the contract after the end of what has caused the delay or has aborted what you're supposed to have done within a specific time, there is nothing wrong for you to perform the contract late, unless if time is of essence. And if that time has elapsed and the man feels that, look, there is nothing we can do about it, you now have to plead force majeure that this has occurred because of work of God. God intervened in this matter. Is clearly not within human knowledge for us to anticipate this, but it has occurred. So I should be exculpated, or I should be mitigated. I mean, the issue of mitigation comes in now. How do you mitigate the loss? That is where issue of facts and evidence comes in. What do you want to do in the circumstance? Parties have to agree. If they fail to agree, the court will be there with an impartial arbiter who sits and then hear all the parties and then makes they renders a judgment either in favor or against. So it all depends on facts of the case at every point in time. But what is clearly in issue and what we should understand about force majeure is most time is not clearly anticipated. I mean, it is not something you can stay here and know this will occur tomorrow, But because of situation, people now make provision for it in their contract.
Okay.
Making sure that it is a clause that in case it does occur, this and this will be what will apply. Okay. I hope you understand what I'm trying to say.
Yes.
Okay. Because of the fact that things like this have occurred in time past, very intelligent lawyers now, when drafting any agreement, must make sure that a clause like this is inserted and then defines what will be the party's right and liability if there is matter like force majeure. So if provision is being made, of course, parties will know their liabilities and rights, whenever it does occur. So there won't be any issue, unless somebody wants to go and test, whether those provisions are still what they provide, then, by going to court. Or if not, if the provision of the contract is very specific as to what will happen, when a matter like this occurs, then it then means that parties will abide with the provision of the contract.
Okay, Mr.
But as I said earlier,
okay, Mr.
yes.
Ubani, I just quickly want to ask you this. There was a circular recently by FIRS talking specifically about some companies doing quite well, you know, retailers and the likes, and taxes. We know taxes are sacrosanct. I mean, I think it was Celine Dion that said rain and tax, and those are the very, very constant things in life. But in a situation like this, what would you advise the FIRS to do better as regards that? Should we tax companies because they are making money in this pandemic?
Which company is making? Oh, well, there are some companies that are making money in this pandemic. Those who are selling food items and those who are into.
So, do we tax them despite the fact that it's a pandemic? It's an unheard of situation. Do we still tax them because they are making money when the economy is not moving?
But yes, I thought that there was a publication from FIRS saying that instead of 31st of March being the deadline for payment of yearly tax, I think they have now shifted it to June, unless I'm not right. I read something like that somewhere or heard it on the news that they have actually shifted the deadline for payment of tax due to this pandemic that occurred in the country. It doesn't mean that they are very much alive to their responsibility, knowing fully well that people are really in economic hardship at this time. So instead of a particular deadline on a date, they have now shifted it, which we also expect every other person to actually reschedule all the arrangement, including debt that we are owing, banks that are, billing people every month and, charging interest. With this thing that has happened, it will be wrong for banks to keep on charging the accumulated interest on this time that all of people are home. So I think there has been a pronouncement by FIRS to answer your question specifically on issue of the deadline for payment this instead of 31st of March. I think it was shifted to sometime either June or July, giving people room now to readjust due to the current reality.
Okay, Mr. Ubani, in a situation where you have stipulated time to seek redress and this happens, what exactly is the remedy for this? Do the days stop counting as the pandemic begins and then starts to recount after the pandemic? Or what is the solution in that situation? For instance, politicians seeking redress who have just 90 days, or political parties who have 90 days to seek redress. What happens in that situation? But also, what are your general concerns for the legal implications of coronavirus that we may be seeing?
Your question is a very intelligent question.
Thank you very much.
I'm sure you're a lawyer.
I'm not a lawyer.
You're not a lawyer. That's a very good one because there is what they call statute of limitation, and time starts to run. When a cause of action arises, and nothing stops it. I'm not aware of any precedent or any decision that has been reached whether time stops when there is a pandemic like this, when there is an issue that has just occurred. This is a new occurrence. In my own generation, I only read about the Spanish flu that occurred, I don't know when my grandfather was not even born. But I am experiencing this in my own generation where we have such a pandemic of this magnitude that one is asked to stay at home. Don't come out of your house. It has never, honestly, you read these things in novels, but we are seeing it practically in your own generation. So I have not read any particular decision where time stops to run due to a general disease outbreak like this. I have not. And I don't think that may have been decided within Nigeria. Talking about Nigeria now, legal precedents. We may have some recourse to foreign authorities on this issue. But I doubt whether time will stop running, especially on the issue of status of limitation. And then for those of us also that have actions that are time-bound, I think the Supreme Court and the Court of Appeal have decided, even during this time, to give a ruling and judgment on those election petition matters that are time-bound in order to ensure that they comply with the provisions of the Electoral Act. And I don't think there is anyone now that is outstanding, knowing fully well on the issue of time, essence of time, in most of these election petition matters. I'm concerned concerning the question you have asked as a lawyer.
My second question. Yes, my second question is about your general concerns, but let's go on a break now so that I don't get to interrupt you when you start to respond. We'll be right back. Stay with us. You're still watching the morning show here on your Rise News, and we're talking the legal implications of coronavirus pandemic globally, especially here in Nigeria. And Mr. Onyekachi Ubani, former NBA chairman, Ikeja branch, Lagos, Nigeria, is still with us. Thank you so much for staying with us, Mr. Ubani. The second part of my question before that break was, what are your concerns with the legal implications we might be seeing from this pandemic? Any concerns at all?
There are several concerns. I have several clients that I filed applications for enforcement of their fundamental human rights. They've been in correctional centers for years now, and their matters have not been brought to court. Their matters have been brought to court, but they have never in any way bring up their matter anymore. So they have been languishing in so I brought several applications for their enforcement. Now, this particular pandemic has actually interrupted and disrupted those proceedings. There's one that I was even about to apply for his bail, who was alleged to have committed, is he rape now? He has been in detention. The matter is before a magistrate who has no jurisdiction, and the matter went to DPP for an advice, and advised funding that he should be charged to court. And so we're trying to bring an application for his bail before this pandemic, So he's been there, languishing in correctional centers. So there are a lot of concerns, for us. I had several cases that are supposed to adopt my written addresses before this pandemic. I have 1 or 2 judgments I'm supposed to have received before this pandemic. So many lawyers that are litigation lawyers, have been made to be idle. No income, and we has brought us to the issue of using technology now in our judicial process. Even many lawyers are still opposed to the issue of technology. I'm happy that you guys are using technology to interview me. So from now onwards, most times I don't need to be in your television house.
Mr. Ubani.
Mr. Oseni will always insist on your personal attendance, but now we have explored technology now, so we can use this webinar now, and we're doing all the things we're supposed to, rather than me driving all the way from Ikeja, driving all the way from Ikeja to come to Lagos Island.
Technology. Corona has changed way of life, including broadcasting. Thank you so much, Mr. Onyekachi Ubani, for coming on the show. That's so much we can take at this time, but your presence is much appreciated.
Thank you so much.